Welcome to the Ask the Expert Show with local celebrity hosts Steve-O and Renee. Sit back each week while Steve-O and Renee educate you with live in-studio experts, such as lawyers, doctors, home improvement, and financial experts in their field. Call in and have your questions answered each week at 888-565-1470. Now, here is Steve-O and Renee with today's expert in their field.
We are live here at the Olympics in Rio on News Row. No one's here yet, though. Don't go swimming, guys, please. Water's pretty bad. Well, this is the first Thursday of the month, so that means time for Kaye, Bender, Rembaum. You guys weren't here last time.
No.
It was. I got to tell you, it was really strange. We've been doing the show for a couple years now. It's weird, both of you not here.
Oh, you wanted to meet Rembaum.
Yeah, we did. We definitely did. So, and if you want to call, listen, they will answer your questions. Call us at 888-565-1470. I've got some incredible news. Starting next month, September the 1st, we are going to simulcast on FM 95.3. So you can listen to us on FM, AM 1470, but remember, write it down, 95.3, starting September the 1st. So we always, the first Thursday of the month, we have our community association law firm, one of the biggest law firms in Florida, Kaye, Bender, Rembaum, and we have our two stars. These guys are definitely stars. Robert Kaye and Michael Michael Bender, they're both here smiling. See, you relaxed a little bit, okay?
Sure.
Feeling better?
All better,
You
yes.
look great.
Thank you.
You were out of town. He's always out of town.
He's a traveler.
Feels that way, right?
Yeah. So we got to start. Who's going to tell us about Kaye, Bender, Rembaum? Because it seems like by our text and our emails, we have new listeners every month. So tell everybody about the firm.
Sure.
Go ahead.
You can come quad me.
You do a word, then you do a word. You do a word.
Ready, go. Kaye, Bender, Rembaum. As you said, we are a community association law firm, which means our practice concentrates in the area of being general corporate counsel for community associations. That's the HOA, the Homeowners Association, the Condominium Association, some cooperatives sprinkled in there. Clients go from Daytona Beach all the way down to Ocean Reef, some over on the West Coast as well. And in our capacity as general corporate counsel, we assist our clients with all aspects of running their community association, day-to-day operations, assisting them with conducting meetings, noticing meetings, conducting meetings, reviewing their governing documents, interpreting the governing documents, updating the governing documents, which a lot of communities are sorely in need of due to the changes in the laws and changes in the statutes, and just life experiences. So we address documents. We address covenant enforcement issues, which come up, enforcing your documents, reviewing, negotiating, or creating contracts that they enter into with different vendors. And then, of course, if they have disputes that go beyond trying to just resolve amicably, and we end up in court, we have experienced litigation attorneys who deal with breach of contract claims, deal with covenant enforcement issues, deal with construction defect matters on a daily basis. And then, of course, as part of the way associations, these are not-for-profit corporations, the way they run is that everybody has to pay in their maintenance assessments. And when owners don't pay, there's a process in place in the state of Florida for the ability to lien and foreclose. Hopefully, people will pay once they get letters of collection, but that's something else that we handle very aggressively for our clients to ensure that they can get all the funds in and have a smooth operation to their association. So it's soup to nuts.
Let's talk a little bit about customer service, because we've never done that before. And I come to your office.
We talk about it all the time.
Well, I come to your office in Pompano. You got a huge support staff there. And
Right.
customer service has got to be really important, that you can get to somebody when you need an answer.
Well, you're absolutely right. Well, customer service, as far as I'm concerned, and Robert's concerned, and Jeff is concerned, Rembaum, customer service is of supreme importance. We bring experience to the table. There's no question about that. I'm not shy about saying so. The attorneys in our firm are very experienced when it comes to all matters of community association practice, and we pride ourselves on that. But there are certainly other attorneys in the state of Florida who share that experience. Where I think we separate ourselves is the customer service aspect that we bring to the table. Like you said, when you call our offices, you get a person. As long as if you call during office hours, there's no automated machines. We have multiple receptionists who will answer your call, direct you to the right person. If the person you're looking for is unavailable, we have other people who could step in and help. But we also instruct our team, and this is from Robert and I all the way down. You call that person back same day, or at worst, you reach back to them the next day. This goes for emails as well. If someone sends an email and it's in an earlier enough part of the day, they should at least get a touch them back to let them know you've gotten it, that we're available. So that's the key with us. We're accessible and we're responsive. And that's huge when it comes to any vendor that you hire. And as far as I'm concerned, when you're hiring an attorney, it should be you're looking at that like you would any other vendor. We have a specialized area that we're assisting the association with, and that's their legal needs. But we still, and that's usually important. They rarely call me just to see how my day is going.
Exactly.
Well, part of that customer service also includes when we communicate to our clients, we do so in a way that they can understand.
That's helpful.
Like you do on this show.
Exactly.
Right. And you know what? What I love about your firm is this is all you do. It's not like you have this long list of shingles. Tomorrow you're doing a criminal case. The next day you're doing family law. This is all you do. Mm-hmm. So it's important. And I just told you a friend of mine just became president of association 6 months ago in Dallas. It's a lot of work.
Sure, and it can be, yes.
And he said, you have to have a firm representing you because there's no way you know how to handle everything.
No, and the law gets more complicated all the time. Case law is changing things. The statutes change.
Fair housing laws are
right. There's federal laws. There's
federal
state
legislation,
laws.
state legislation. It is tough, and that's also one of the reasons we do a lot of free education.
Well, speaking of court cases, has there been any landmark cases?
Well, there has been one that has been classified as up there as a landmark type case in that it addressed a prior ruling that was creating some confusion in the courts in the collection field. The original case from 2012 is known as the Quatermain case. It involved a situation when a lender had foreclosed and taken title, didn't pay the association. The association started collecting on the lender, started foreclosing. The lender decided something was wrong with its first foreclosure and vacated that judgment, started over. Ultimately, the court decision was that because of a certain statute that's referred to as a lis pendens statute, which requires a document be recorded in the public record to identify the lawsuit that affects the real property so that everybody is aware of it, the court held that when the lender has filed such a document, any other unrecorded claims have to be made in that lender's case. And the association's claim was not in that case, and they called it an unrecorded claim. Well, recently, we've had a decision that we helped to bring about in a case.
Your firm did?
Yes, we did.
Wow.
This is a case that our firm handled very aggressively.
Jalali versus Knightsbridge Village, in which the homeowner, Mr. Jalali, tried to raise that other case as a defense years into litigation, and the appellate court ruled that the association's interest is actually a prior recorded interest by virtue of their recorded declaration of condominium or covenants, whichever the case may be, which exempted them from having to file in the lender's foreclosure case. In the 4 years since the Quatermain case came out, it has caused a lot of problems for associations in pursuing their collections, some of which were already completed and they got reversed, where the association had to give money back to a third-party purchaser that had acquired the unit from the association's foreclosure, held it for years, didn't pay the association, collected rents, and then turned around and got their money back. That's a crazy thing to have happen. So right. This case helped to eliminate all of that, and statewide, it's very helpful.
So you like this new law?
It's a very good case. Yes.
We fought very hard for it.
Now, they did file a motion to have it reconsidered, and the court is still considering that motion, but we fully expect the court to stick with the decision that they've made.
Okay, well, as always, we get a lot of calls to the show. Our number here is 888-565-1470. Let's go to our first caller, Dominic.
Hello, Dominic.
Hi, how are you today?
Doing well. You?
Good. In our condo docs, it states there are no pets allowed. However, since then, we've been having people buying condos with service animals. How does our association know if they're a service animal or just a plain pet?
Dominic, that is an excellent question, and you and I could let everybody tune out of and talk for about 2 hours on that if we had the time.
Oh, okay.
So I'm going to give you a short and simple. The situation that you're basically, the answer to your question is all associations, whether you are a no pet building or whether you allow pets with some restrictions, should adopt policies to how to address the requests for what actually are properly termed assistance animals. You mentioned service animals, and service animals are what they are called. They're called service animals under the American with Disabilities Act, the ADA, and they're a very specific requirements under the ADA. That's where best example is a seeing eye dog. I believe you're probably more referring to the assistance animal, one that or a companion pet.
The therapy dog.
The therapy dog, right? It isn't obvious, because if someone comes to your community and it's obvious they have a disability and it's obvious the need for the dog, then there is no more questions to be asked. You can ask them to fill out just some paperwork, ensure the dog has its shots, but that's it. But where it's a therapy dog, as you say, or a companion animal, it's typically their disability is not obvious, nor is the need for the animal obvious. And so the law does permit, and in our opinion, obligates the board to undertake due diligence. And that due diligence is to request of the individual to provide documentation to support that their request for this particular animal is viable and valid.
And these are fair housing law requirements as opposed to ADA, right?
Correct. This comes under fair housing laws as opposed to the American with Disabilities Act, because fair housing addresses places of residential communities like your community association, whereas ADA only applies to places of public accommodation.
Like restaurants.
So with regard to that, so you should undertake due diligence. We offer a course. In fact, we actually offer the course next Tuesday, August 9th. We'll be giving a course on fair housing, assistance animal versus pet at our Pompano Beach location at 6:30. If you're interested, it is free. And one of the things when I teach the course, I always say in the beginning is, if you get a request for an animal that in a no pet building, never say no, but don't automatically say yes. You do have the right to ask for information, documentation to support that. The best way to do it is if the board adopts a policy, a written policy, an application package, if you will, that we've done for a lot of our clients, and that if someone says that this isn't a pet, it's my therapy animal, then you can hand them that's okay, great. Would you just please get all this documentation filled out and return it to us so we can consider your request for a reasonable accommodation? Because that's what it is. You're a no pet building, so you have a restriction that says no pets. Someone coming in with a therapy animal is saying, I am asking to be allowed to violate that provision, but by asking for a reasonable accommodation to that provision, which under fair housing laws, you, the association, must give if they have provided sufficient documentation to support the fact that their request is valid and viable. What documentation you can ask for, what's presented, and can you ask for more, how you can ask for it. All of these things are questions that we do discuss in the program, but still, bottom line is you should be getting with experienced association counsel on how to handle these things on a going forward basis. And they are case-by-case approaches at times, because you'll get, we have communities where individuals are coming in requesting multiple animals and then trying to claim they have needs for multiple animals. Fair housing laws are very, very liberal. The way I basically put it is, these fair housing laws have been created to benefit the few at the expense of the many.
For the many.
It is. And that's not necessarily a bad thing most of the time. There absolutely are reasons these laws are in place, and I want to be clear, I support that. What the problem is that too many people have taken advantage of the fair housing laws with regard to these assistance animals, therapy pets, and are abusing them and turning these no-pet buildings into pet buildings under the umbrella that these are not pets, they're therapy animals.
Right.
And if you deny a request that should have been approved, you're opening yourselves up to a discrimination claim, which you would prefer to avoid. And there could be fines, there could be attorney fee costs involved in dealing with that. So the expense to the association is one that you would prefer to avoid.
Right.
But there are competing interests because you have a lot of people who've moved into your building who said, "Hey, I don't want animals in here," and that's the board's in a rock between a rock and a hard place.
And a lot of these buildings are not even animal appropriate. They don't have facilities that animals would fit into very well. But
When one of them starts barking, they all start barking. So
right.
Well, and you do have the even if it's a qualified animal, they do not have the right to be a nuisance. They can't be aggressive. They can't be urinating everywhere. Certainly can't be barking. And there are rules and the boards need to adopt these rules and regulations which govern these types of animals as well, and they can be enforced.
okay.
But definitely get with association counsel who's experienced in handling these types of matters to guide you on preparing perhaps an application package, or certainly to address if someone gives you a letter, whether you can ask for more information or where you should go with it.
And if you can come to our seminar, that would be helpful for you. And there's one this month. There'll likely be one next month as well. Or maybe not, maybe 2 months, but at some point.
But all your seminars are free.
They are free, and we'll talk about it more during the show, so please listen. I think we have a break coming.
Yeah. Hey, thanks for calling,
Thank you,
Dominic.
Dominic.
All right. Thank you.
We're going to go to break. We come back. We have more with Kaye Bender Rembaum. We'll be right back.
Is your community association looking for prompt, effective, cost-efficient, and understandable legal advice and services? You'll find that and more with Kaye Bender Rembaum, a full-service commercial law firm concentrating on the representation of more than 800 community associations throughout Florida. With offices in Broward and Palm Beach counties, Kaye Bender Rembaum assists clients in all matters of association representation, including but not limited to collection of assessments, contract negotiation, covenant review and amendment, covenant enforcement, and construction defect claims. Under the direction of attorneys Robert Kaye, Michael Bender, and Jeffrey Rembaum, Kaye Bender Rembaum is dedicated to providing clients with an unparalleled level of personalized and professional service regardless of their size, and takes into account their individual needs and financial concerns. For more information, visit www.kbrlegal.com or call 954-928-0680.
And we're back. We've got more phone calls.
Let's get right to them.
Let's go to Pauline. Hi, Pauline.
Hi, how are you?
Good. You have a question for Robert or Michael?
I have two questions for you, actually. One is we have a board now where the president does not follow Roberts, which is suggested strongly in our documents. He has eliminated all committee meeting reports. He does not go over the financials at the board meeting. And he feels that they should discuss things outside of the board meeting, not in front of the people who are there. That's one. And the second one was we just received our phone books, and the rules and regulations that had been voted on by a prior board after having been discussed with the community and gone over very carefully were now published in this year's phone book. They've been changed. There was never a discussion at a board meeting about them. They were never reviewed by the membership. And it seems as though we have one gentleman on the board, not the president, who seems to take it upon himself to do many things without consulting the board, but our president just doesn't seem to care. How do we handle this?
You say you're a condominium, right?
No, we're an HOA.
HOA. And how many board members are there?
7.
And how many homes are in there? 186.
Okay.
Is there a lot of interest by the homeowners, or are they mostly apathetic?
Kind of thrown up their hands because this is the 8th month, so the first 6 meetings that we had, the first 3 the president spent living 20 years ago and telling us everything that he accomplished then. After that, the board meetings got so bad and there was nothing happening at them. We didn't learn anything about the financials, about what the committees were thinking about, what the board was thinking about, that the meetings have now become limited to 15 minutes or less.
Okay.
People just don't go anymore because
Can it do that?
Well, the board can do
a
a lot of things in ways that people think they cannot. And first off, if your bylaws contain provisions that have an agenda for the meeting and contain the requirement of using Robert's Rules of Order where applicable, those are things they should be following, but not following doesn't necessarily equal actionable legal issues for them. So long as a quorum of the board is present and the board takes action by a vote of a majority of them, for the most part, the actions they take will be...
No votes taken at the board meetings. We have no idea what they've discussed or how they've voted.
Well, the board has to act either at a meeting in which a quorum is present, or they can take action by a written consent or written resolution, so long as it's signed by 100% of all board members. So if they're doing their business by written resolution, there has to be records of it in the association's official records, and there has to be 100% agreement by all board members to the action that's taken. And rule changes are something that also typically require notice to the community to become effective, and they can't be done in secret. So changing the rules governing the use of the property or the use of the common facilities, assuming the board even has the authority to make such rules, that would be something that has to be provided notice to the community, depending on if it's involving the property. The individual lots or the common property will depend on what kind of notice is required, and you probably have both kinds in your rules.
Yes, we do.
So your best efforts to make is to change the board with people who are like-minded with you. At the upcoming annual election is best, but if you can't wait that long, then there is the opportunity of recalling the people that want to do things in a way that is not in the best interest of the entire community.
Does that answer your question?
Kind of, if I'm understanding you correctly. If they do it by written resolution, they need 100% of the board signing off on it.
Correct. And that has to then...
If 100% of the board does not sign off on it, what?
Then they have to do it at a meeting at which there's proper notice. Owners have a right to attend and participate. And then it's by a majority vote of those present, so long as a quorum is there. So you have 7 board members, at least 4 have to be there, and then 3 of the 4 would have to vote in favor of whatever issue it is.
Okay, but it needs to be discussed in front of the membership.
It should be, yes.
Okay, that was part
No,
of the
they are allowed to talk to each other outside of the meeting. They're just not allowed to make decisions that way unless it's 100%.
Okay, well, thank you so very much for your time.
Hey, thanks for calling.
Thank you, Pauline.
Keep listening.
I intend to.
Good question, huh?
There are
Yes.
good questions, yeah.
So the number here is 888-565-1470. As you can see, this is the place to come for your questions if you're a board member, property management company. Now, you've got classes coming up.
We do.
We've never gone this late in the show before we got here. Also, by the way, give everybody your website because they can actually watch our show live right on your website.
Well, what's left of it?
Yeah, but you can't tell you something. Your website, because we look at a lot of websites, amazing.
You mean kbrlegal.com?
That's the one.
Yes.
What was that again? You know, the ears go out
It's
sometimes.
KBR, like Kaye Bender Rembaum, legal.com.
But you really do have an informative website because I've seen them all over the country. So tell us about some of the classes that are coming up, the free classes.
Well, as we briefly talked about with Dominic earlier on the phone, we are offering our Fair Housing Act seminar, Assistance Animal or Pet. We have added, over the last few months, we've added some new classes, and so we haven't done the Fair Housing Act in several months. We've had a lot of issues coming up, a lot of people asking about it, so we have it scheduled for Tuesday, August 9th in our Pompano Beach office. And just so everybody's aware, who are new listeners, Kaye Bender Rembaum, we do have 2 offices. We have main office in Pompano Beach, Copens and Andrews, right off 95. And we have our second office in Palm Beach Gardens, which is 9121 North Military Trail. Both offices do hold education classes for free. They are free to attend. They are in the evenings. And Tuesday, August 9th in Pompano Beach will be our Fair Housing Act seminar, Assistance Animal or Pet. And on Tuesday, August 23rd in Pompano Beach, we will be doing a board member certification course for homeowner association board members. In Palm Beach Gardens, we have 3 classes this month, and they are on the following 3 Wednesdays. Wednesday, August 10th will be an HOA board member certification class. Wednesday, August 17th will be a condominium association board member certification class. And Wednesday, August 24th, one of our new classes, guest restrictions and screening tenants and new owners. Is it worthwhile? Pompano Beach will have that class in September. We'll talk about it next month. But these classes are all free to attend. They do fill up, so we do recommend you RSVP. Hold your spots. KBRlegal, legal.com. You can go to the site to sign up for these seminars. As you mentioned, we have great resources on there as well. In the resources tab, you drop that down, you'll see Rembaum's Roundup. You'll see Legal Morsels. Both of those tabs contain great articles on the Jalali Quatamine decision Robert talked about, on the fire sprinkler retrofit issue for condominiums, which is a very confusing and hot issue because condominiums do need to retrofit fire sprinklers or vote to opt out of retrofitting their fire sprinkler system before the end of this year. And if they don't, they have 3 years to spend potentially tens of thousands, hundreds of thousands, or millions of dollars in retrofitting their sprinkler system. There also is additional requirements that they may have, whether or not they opt out. So we encourage people read this website and contact your local council to talk about retrofitting.
Now, there's got to be people driving home right now thinking about maybe becoming a board member.
Maybe.
Tell them about these certification classes that you need to have the certification.
You do. In the state of Florida, to be a board member on a homeowner association board, condo board, co-op board, even a mobile home community now, they just added last year, you do need certification, board member certification. There are two ways to get that certification. One is to fill out a form that the state has created that confirms you've read your governing documents and you promise to uphold them, meet your fiduciary obligation to the association, etc. The second, and my recommended way, is for people to come to a division-approved board member certification class. Even
Your
if you
classes.
which we offer, we are division approved. Even if you fill out that form just to meet the requirement, because the law says you have to have certification within 90 days of being elected or appointed. So if you're elected or appointed to your board and you know you can't make one of our classes in the next 3 months, fill out the form the state gives to be certified to be in compliance and give it as part of your official records. But then schedule to come to one of our classes or multiple classes on board member education throughout the year. Those are offered. HOA classes are offered 4 to 6 times a year. The condominium board cert's offered 4 to 6 times a year in our offices. And I do encourage people to come. If you are thinking about being a board member and your elections are within the next 12 months, come and take the class now. Get more information. Maybe that'll convince you to do it or convince you not to do it. I don't know. But the certification, if you take the class, is valid for 1 year from the date you take the class. So if you come to our HOA class at the end of this month and your election is next March, next April, next May, you can, once you get elected, you can then put that certification on file. You're already in compliance.
Well, we are going to go to break in just a minute. When we come back, there's people who don't even know what's involved in being a board member because they've been on the outside. They've never seen how much time does it take, what kind of background do you need. So when we come back, I want to talk about some of these things because there are people out there that are tired of fighting and they want to get on the board and try to do something about it. So we're going to go to break, and when we come back, we have more with the guys.
Is your community association looking for prompt, effective, cost-efficient, and understandable legal advice and services? You'll find that and more with Kaye Bender Rembaum, a full-service commercial law firm concentrating on the representation of more than 800 community associations throughout Florida. With offices in Broward and Palm Beach counties, Kaye Bender Rembaum assists clients in all matters of association representation, including but not limited to collection of assessments, contract negotiation, covenant review and amendment, covenant enforcement, and construction defect claims. Under the direction of attorneys Robert Kaye, Michael Bender, and Jeffrey Rembaum, Kaye Bender Rembaum is dedicated to providing clients with an unparalleled level of personalized and professional service regardless of their size and takes into account their individual needs and financial concerns. For more information, visit www.kbrlegal.com or call 954-928-0680.
And we're back. We're here with the Kaye Rembaum Bender. Kaye Rembaum Bender.
Kaye Bender Rembaum. Try
we
again.
do this every Thursday. The first Thursday of the month. And we've got actually 2 callers. So let's go to our callers, and we're going to come back, and
Let's
we're
go
going
to
to
the
get more
callers.
dates and times. Let's go to Laura first. Hi, Laura.
Hi there. Thanks for taking my call.
Oh, thanks for calling. You have a question for Robert or Michael?
I do, either one. I live in an HOA, and last year when we had our, budget talks, we had a gentleman that did not want to communicate with the community, so he made up his own budget, never shared it with the community, and never put any money into the, not the contingency, but...
Reserves?
I'm sorry, what?
Reserves?
Yeah, he didn't put any money in the reserves. And now we are halfway through the year, and they're taking money out of the contingency to pay for things that should have been budgeted. What do we do?
You're not a member of the board, or you are?
I am.
You are, okay. And the person who
Who is
came
this
up with this
person?
budget, was he a board member as well?
Not anymore. He quit.
Oh, okay. He makes up a crappy budget and quits, right?
Yep.
Well, the law allows you to adjust your budget at any time during the year as you may deem appropriate as a board. You can either adopt a new budget, or you can do a special assessment to make up whatever shortfall the budget indicates to cover the needs of the association.
Right.
If you do a new budget, it's basically the same process as when you do your original budget. Whatever notice you provided to the owners then is the same.
Yeah. Well, that was the problem. They didn't notice anybody.
Well, they should have noticed the board members,
Well, we saw it after it was all done.
but you still would have had to vote for it.
Not until... Well, I don't remember if we did.
Well,
I know we got it in the mail
you should.
like 3 months after.
Right. For many reasons, it seems that you might have it'd be a good idea for you all to consider creating an amended budget, and then a 14-day notice to the membership of that meeting. It's a board meeting,
Oh,
and at that
okay.
board meeting, approve the amended budget, and then give new coupon books or new statements or however you do it.
Okay.
Do you have a property management company, or you're self-managed?
We have a property management company, yes.
Okay, they should be able to help you through that process.
Okay. I am...
You can inquire of them, and if
Well, at the end of the year, so it's kind of tough.
Well,
Well,
that's why a special assessment may be the way to go. Now, with respect to your statement about reserves, for homeowners associations, the law was changed a few years back to create the ability to have what we call statutorily protected reserves, meaning they can only be used for the purpose you're holding them unless the owners vote to do something else. But in order to have those, you need a vote of the owners in the first place. If you don't have such a vote of the owners in the first place, or if the developer of your community did not put them in, which most communities that were developed prior to the statute would not have that, so it would take an owner vote. Then unless you have that owner vote, then anything you call reserves are basically a contingency fund as you have, which can be used to offset any budgetary shortfalls that you run across during the course of the year. Now, if you wish to have a pool of money for a specific purpose, such as redoing roads or other maintenance issues that are generally high dollar value but don't happen very often, then you would need to have a vote of your homeowners to establish that type of reserve account. Once you do that the first time, then in the same way as condominiums, you have to have full reserves every year unless the owners vote to have something less or no reserves.
Now, would you vote a specific dollar amount, or you just say you want to have a reserve line item?
You would be voting to create the reserve line item, but you would have to specify what those line items are.
But with a dollar amount, or just
Not
what they
necessarily the dollar amount, just the category.
Right. Well, the appropriate approach, I would say, I would add is if there's certain like Robert mentioned, your roads or certain other items in this HOA that the association has responsibility for, you have a reserve study done, and that
We did do
reserve
that,
study would
and-
establish. And that shouldn't be too expensive either, but it would establish the life expectancy of, let's just use the roads, and the estimate it would be to replace the roads. So say the roads are going to be $200,000 and they're going to last 20 years, then you should be reserving $10,000 a year. and then
Right.
that's how you would determine what your budget amount would be for reserves.
Right. Well, we did do that, but the gentleman that took care of our finances doesn't agree with reserve studies, so he wouldn't implement any of it.
Okay, well, no individual should have that kind of control over your association. It's going to be up to a majority of your board members for the final decision. So hopefully you could convince them all to be more involved.
Well, that's a good point.
Yeah.
Yes.
Well, if you have a need for association counsel, then by all means,
Give 'em your phone
we'd
number.
be happy to assist. It seems as if the board could definitely use some education as well, and we would invite all of you to attend any of all of our classes.
Yes, I've been to several of them.
Oh, great.
good.
Well, then you have our information. If we
So
can
you
be
know
of
the
assistance,
value.
let us know.
All right. I appreciate your help.
Thank you.
Thanks
Thank you
for calling.
Laura. And to call us, it's 954-928-0680 or 1-800-874-0680. Or I'm sorry, 974-0680. And Palm Beach Gardens, do you have that phone number handy?
561-241-4462.
Okay, great.
Thanks so much, Laura.
Thank you.
Let's go to Fernando, who's been holding for a while.
Hi,
No?
Fernando.
Fernando.
Fernando,
Got tired of holding?
Fernando,
Bill,
call back.
Call back, Fernando.
So give everybody your phone number, first of all.
Just did.
We got to do it.
1-800-974-0680. You can call that number, always get receptionists, and they can direct you to either Pompano Beach or Palm Beach Gardens offices. If you wanted to call Palm Beach directly, 561-241-4462. Pompano Beach directly, 954-928-0680. Reach us through our website, kbrlegal.com. You can email us at info at kbrlegal.com to request free consultation, meetings, etc.
So we have a few minutes before we go to break. Tell people what is involved in being a board member. Because, listen, today we're hearing people complain a lot. A lot of people might not know what's involved with it. A friend of mine thought you would have to have a master's degree to be the president.
Well, it doesn't
or
hurt.
a CEO.
But there are no specific requirements other than being over the age of 18 years and not a convicted felon whose civil rights haven't been restored for more than 5
What about
years.
a business background? Does that help?
It help. A lot of things will help, but a lot will depend upon the community that you're serving on the board as to what background would be beneficial or not. Because if you have a very full-service, capable property management company that is trustworthy and all of that, then the board members have more oversight responsibility than actual hands-on, and their time involvement may be less because they're delegating that to their agent, the property manager.
Is there a lot of time involved in being a board member?
Again, it depends on
I
the
would say.
situation and also the desire of the individual. You could be a lot or a little. I mean, technically, board members have the responsibility of attending board meetings and voting on issues that come before the meeting, and that's it. A lot of people get involved in the more day-to-day aspects of it because they're a board member, and that's technically not correct. It should be the officers of the association that do that, the president, vice president, secretary, treasurer, who are typically from among the board, but sometimes some of them are not.
Presidents sometimes?
Usually the president is required to be a member of the board, but secretary and treasurer often are not. And sometimes you don't get volunteers from among the board to do that. Secretary and treasurer duties are things that property management typically does, mostly keeping the records as secretary, keeping the financials as treasurer. That's something that the property management would do. Being as educated about community association aspects is the recommended approach, regardless of what your background is.
Right.
Being committed to making decisions for the benefit of the community without your own personal self-interest being involved is
That's the
important
biggest
as
one.
well.
That's the toughest one,
It's
right?
difficult for people to separate that sometimes. They have their personal agendas that they want to bring forth to the community, which may not be in sync with what is best for the entire community. So you want to try and avoid that. Many other attributes come into play, but there is no set one one thing's more virtuous or better to have than another.
Good. I would say if you're planning on volunteering, it's a volunteer position, and we're gonna. I know there's a call on the phone. Donna, we're gonna be right with you. Go on the board open mind with a desire to communicate with others, work well as a team player, and recognize. And I say this to all board members or people who want to be board members. It's okay to disagree. You can have disagreements, but do so with respect, with courtesy, with professionalism. You are running, these are businesses.
Right.
They are big, some are large, some are small, but they are businesses. And so treat them as such. Step outside of your, and treat them and act like a responsible professional business person when running your association. Use your experts. Get a good management company. Get a good attorney, good accountant, good insurance agent, those kind of things.
Okay. Hey, let's go to Donna. Hi, Donna.
Hi. My name is Donna Franklin. I'm actually on the board of directors at Waterford Courtyard South in Deerfield. I've been on the board for about a year and a half, and I did take your course when I became a board member, which was very informative and helped me. We have something coming up soon. We're going to be having an assessment we're planning on for January of 2017. We have 116 units in the community. And 30% of the homeowners, 30 homeowners, are behind and delinquent in their payments. Our lawyers have contacted them, and they are paying, fees for that. My concern is when this comes along, and it's for roofs and mansards and possibly fences. The prior management company that was here for 15 years kind of let everything go. So this new board is kind of picking up the responsibility, and it's way overdue and needs to be done. So our property manager is looking into roofers and the bank and everything that we need to get prepared. My question regarding our financials, the bank that we choose, that chooses us and we go with for this loan, what will happen with these people that for quite a while now have been delinquent? How will these people, if they can't pay their maintenance fees, take care of an assessment? That might be $8,000 for each homeowner. How does something like that work?
Well, that is definitely a factor that the lenders will be looking at when they're considering whether or not to loan the association money. And if you're saying 30% is your delinquency currently, that may be outside the parameters that most lenders are willing to accept. Another possibility, if you find a lender that's willing to provide a loan under those circumstances, you may be facing a higher interest rate or additional costs in order to get them. There are companies out there that can assist in delinquencies. There are companies that will basically take on your delinquencies for you, such as a company by the name of LM Funding. They're based out of Tampa, and they will take on your delinquent accounts, start paying the association on a going forward basis to give you current assessments, and then pursue the collections themselves.
So we have to pay this LM Funding for their services?
No, they don't charge the association for their services. They have various programs. Obviously, they're not in the business to be a charitable organization, but they're taking on some of the risk, and depending on the program that one chooses would be whatever it is that they're ultimately going to be taking on. But it's something that can be considered. Aggressive pursuit of the delinquencies by the board is always recommended. It sounds like that wasn't the policy before to allow for such a high delinquency rate now. Under current financial conditions, your delinquency rate is well above the norm these days. So,
and the board lawyers are, taking care of the fines and et cetera on that.
Well, the other problem to the association in that approach is that the lawyers aren't doing it for free either, and if the people can't pay, then that's just digging a deeper hole for the association as well. So that's a concern to keep in mind.
And we were also wondering if these people are delinquent, behind, how would they be able to afford the assessment?
good
where would that
question.
go?
Well, it's a good point, but the maintenance still has to be done, and the expense has to be taken on by the association. So, if owners aren't paying, everyone else has to make up the difference. And if you can't get a loan, then any special assessment you adopt to cover it has to take into account the possibility of a percentage of owners that aren't going to be able to pay. So you'll have to increase the amount to make sure you have enough money for the work that needs to be done.
Wow, that's really interesting. So it's LM funding.
That's one of the companies that we're aware of that does this type of work.
Okay, and they're out of Tampa.
Donna, if you send me an email, I will put you in contact with the people over there, the local representatives.
Wow, okay, terrific. And what is your email, sir?
It's mbender@kbrlegal.com.
And anyone else who wants to send him an email,
mbender at
kbrlegal.com. kbrlegal.com, like our website.
Perfect.
or if you go to the
Thank you so much
website, you can click onto the info or the contact information, and that will find its way to us.
Usually
thank you so much,
you can reach
sir.
Michael
What's
around
that,
2
Donna?
a.m.
What was that? Donna?
Yes, I just want to thank you for your time, sir, and I will email you. It's been very informative. I appreciate it.
You're very welcome.
And
Thanks,
good,
Donna.
Good luck with the project.
Thank you so much. Bye-bye.
Wow. Hey, let's go to a quick break, and we come back. We got more.
Is your community association looking for prompt, effective, cost-efficient, and understandable legal advice and services? You'll find that and more with Kaye Bender Rembaum, a full-service commercial law firm concentrating on the representation of more than 800 community associations throughout Florida. With offices in Broward and Palm Beach counties, Kaye Bender Rembaum assists clients in all matters of association representation, including but not limited to collection of assessments, contract negotiation, covenant review and amendment, covenant enforcement, and construction defect claims. Under the direction of attorneys Robert Kaye, Michael Bender, and Jeffrey Rembaum, Kaye Bender Rembaum is dedicated to providing clients with an unparalleled level of personalized and professional service regardless of their size, and takes into account their individual needs and financial concerns. For more information, visit www.kbrlegal.com or call 954-928-0680.
And we are back. We are with Kaye Bender, Rembaum, the boys. We're here the first Thursday of each month from 5 to 6. There's people out there have some problems. And
we're
this
here to
is,
help.
yeah, this is, if you've been listening to the show over the last year or two, these guys are amazing. So let's go back, because there's always new people. You've got some free classes coming up.
Yes, we do. For you new listeners, we have education in both our Pompano Beach and Palm Beach Gardens offices. You can go to kbrlegal.com, and there's this seminar schedule. If you are interested, you can send your information to info@kbrlegal.com. And as I mentioned, if you're association looking to get a free consultation, or if you want to just get added to our email list for updates on our class schedules, you can give us your information there as well. Tuesday, August 9th, we'll have a Fair Housing Act class talking about assistance animals versus pets. That's in Pompano Beach at 6:30. And Wednesday, August 10th in Palm Beach Gardens, there'll be the HOA board member certification class. Wednesday, August 17th in Palm Beach Gardens is the condominium board member certification class. And then the last week of the month, Tuesday the 23rd in Pompano, will be the HOA board member cert class. And Wednesday, August 24th in Palm Beach Gardens will be a new class on guest restrictions and tenant approvals. All excellent courses, all start in the evening. Palm Beach Gardens all start at 6 p.m. Pompano Beach starts at 6:30 p.m. KBR
Free.
Legal,
All free.
Light snacks provided. RSVP because space is limited. 954-928-0680 for Pompano Beach. 561-241-4462 for Palm Beach Gardens. Or if it's easier to remember one number, it's 800-974-0680. You can get at either office there.
I'm going to give out the phone number one more time in case someone has a quick question. 888-565-1470. So are people upset with this Fair Housing Act that no longer restricts renters from basis on criminal records now?
Well, that's not exactly the status of the law. HUD, the Housing and Urban Development, a federal agency, an arm of our federal government, had issued a guideline, which is not law, but it is an indication of how HUD is going to view things in discrimination complaints, that said the use of criminal background to disapprove a potential renter or purchaser can be the basis of a discrimination claim. Not necessarily would be. Depends on the circumstances, depends on whether or not it was a conviction or just an arrest record, what the type of crime it was, how long ago it was. So the blanket, any criminal background is grounds for disapproval, is suggested to not be the basis that people use anymore. Certainly people are upset and confused because there is some concern that nobody wants people with criminal backgrounds to live in the community.
Are the penalties high?
The penalties can be high. It could be $10,000 for the first violation for a discrimination claim. So that is something to avoid. But
can't emphasize enough the importance of getting with experienced counsel on these types of issues. Get guidance and rely upon that guidance.
We do have an article on this on our Legal Morsel website for somebody who on our website at the Legal Morsel tab. If anybody wants to read it in depth.
Let's go. We have a phone call, so we only have a few minutes left. Let's go to Javier.
Javier, hello.
Hi, Javier.
No, Javier hung up.
Okay.
Javier, you didn't give us but
Javier, you were so impatient.
Enjoy your ride home. Did you give out all the classes already?
Yes.
Okay. So we got that.
I can finish on the criminal side.
Good.
It's recommended that associations have a formal policy in place if they're going to include criminal background as a source or one of the items they'll be considering in their background checks, and they should consult with the association council to make sure that the whatever they decide upon falls within the guidelines that HUD has suggested if they want the most protection. Now, someone's going to have to actually make a complaint of discrimination if that's ever going to come into play, and whether or not that happens, it's hard to really predict.
But it could.
It could.
It's likely.
And
These
because
days.
of the
Is that right? It is likely.
I think it's
these
more likely
days,
than
it's
not
more
these
likely than it
days.
used to be because of all the publications that go on about it. But you shouldn't think that criminal background is no longer allowed to be a factor. It is. Certainly, if you have somebody with a sexual predator background or convicted sex offender, you have somebody of violent crimes that they've been convicted of and or pled guilty to. You have situation if it's a manufacture and distribution of controlled substances, that's an exception under the Fair Housing Guidelines. You don't have to worry about that as an issue. But possession is one that's not protected. So you'd have to keep that in mind. Burglary, things of a violent nature. Somebody has some white-collar crime or was convicted of possession of marijuana in 1997, that might not be a good basis to disapprove a rent or sale application under the current guidelines.
Let's give everybody your phone number again.
800-974-0680. Just piggybacking off that, I think with the points that Robert just made, which are all spot on, it's not really it's not it shouldn't be a major or drastic change from where boards are. We've always counseled our clients that where criminal background is going to be used as a good cause basis to disapprove, presuming you have the right to disapprove. And that's step one, by the way. Do you have that right? You should be. It should be something. The crime should be something, as Robert talked about, the particular type of crime, the time frame that it occurred in. Someone I had an example where someone wrote a bad check when they were 19 or 20, and that was considered a felony. So you're not gonna, and now they're 40 in their 40s. You're not disapproving them for that. You shouldn't be. I think that the guidelines are that HUD puts out. can be frustrating because they definitely put an extra burden on associations, which in some cases is unnecessary. But
Plus, it scares them.
it does scare them. But in practice, I think that, again, get with experienced counsel. I can't emphasize that enough. You get with experienced counsel.
You shouldn't try to do this on your own.
Well, that's the
and that's
point.
what we see on the show, that you need.
Well, it's not your home. It's not your.
Experienced
It's not your
counsel.
home. You know, it's not. We're not. You're not. It's not your individual lawyer. You're asking. You're running that business, and have a line item in your budget to address your experts. You have one for your CPA to do your audits and your things. You have an insurance agent who comes in there. You have maybe have a management company. Have a line item in your budget for legal, and use your legal when you have legal needs that come up for the association.
Don't be shy.
Corporate businesses will have legal needs. And, and there's a lot of issues that go on. And so you want to run your community smartly, come out, get our free education, and then utilize your experienced counsel to help you on day-to-day matters when they come up.
What you said, there's a lot of issues that come up.
There are.
And again, I'm saying, don't try to handle this yourself. You need experienced counsel like your company, your firm. And it's one of the biggest firms. And I don't know how you charge, but just because you're the biggest doesn't mean you're the most expensive either. So I think
No, we're certainly not the biggest.
We're definitely not the biggest. We
that whole 30-story building you have.
really, as far as, because you mentioned it a couple of times, let's just clarify, we do have the experience that a, quote, big firm would offer. But we give the customer service and we treat our clients, I guess, as a boutique firm would. So it really is the best of both. You get the experience of the big firm, and the resources of a big firm, but the boutiqueness of the customer service aspect. We do not nickel and dime our clients. We're in this for the long haul. It's 25 years in continuous in practice, and there's a reason for that.
1 hour goes by fast.
Thank you, callers. See you
Yes,
next
great
month.
calls today. And we'll be back next month. And we'll be on 95.3 and 1470, both next month.
Thank you.
The name of the firm is Kaye Bender Rembaum, and we'll see you next week. Thanks for listening, everybody. Peace and love. Great show, guys.
Thanks.
Thank you.
Thanks for tuning in today to the Ask the Experts show with Steve-O and Renee. Tune in every Friday from 4 to 5 p.m. while some of the top local experts in their field from Broward and Palm Beach counties educate you in the areas of law, health, financial, and home improvement. You can also call our offices at 888-574-6999 to become an expert on our show. The opinions expressed on the preceding sponsored program were strictly those of its hosts, guests, and callers, and not necessarily those of this station, its staff, management, or sponsors.